GAGNE. 24P 1049. I'll ask council to approach.
Good morning. May it please the court. Laura Mannion on behalf of the defendant appellant James Gagne. In this case, the complainant described a brief but unwanted, invasive touching of an intimate area of her body that, if intentionally committed by the defendant, would constitute an indecent assault and battery. So before getting into what I think are really the two key and interconnected issues about intent and the sufficiency of the intent and also the absence of the accident instruction, I think, if I may, I'd like to really clarify what it is I'm not arguing, because I hope I don't get a question about what's my best case, because I don't have an answer, because there's no case that I've found that's anything like this, and my arguments are really distinguishing cases. But I want to make very clear, consent, we're not arguing consent. It was abundantly clear this touching was unwelcome, and no reasonable person, intoxicated or not, his intoxication has nothing to do with a sort of Kennedy type, couldn't tell that she wasn't consenting. No reasonable person could believe that. The nature of the touching, over the clothing, the thigh and the vagina, the inner thigh and the vagina of a female, whether clothed or not, is an intimate area of the body that a female has an absolute right to not have touched without her consent. The duration, we're not arguing that the touching was too short to have been indecent or intentional. There's no threshold duration for the amount of time a person has to endure a sexual assault. 1 to 2 seconds is 1 to 2 seconds too many. There's certainly no argument that the defendant was unaware that he couldn't do this. It's not like Commonwealth versus Cruz, where everyone could agree, yeah, this was really creepy, but is it criminal? There's no question of that. And finally, we are not arguing that the evidence of intent was insufficient because the evidence was inconsistent. The argument is that the evidence, direct, circumstantial, of intent was consistently absent in this case. And for that reason, a conviction for indecent assault and battery, which, although a general intent crime, still requires intent, was insufficient to even make it to the jury. And
Okay, so intent is always based on inferences from the record. You're saying there are no inferences that could be drawn.
There are no reasonable inferences, Your Honor, and unless and until the Commonwealth can point to some evidence that could lead to some reasonable inference that a silent, short, quick touching between a man and a woman where the uncontradicted testimony was he had never interacted with her in any way. Not just that he didn't make sexually suggestive comments, which do appear in just about every single case we have on indecent assault and battery. Because the brief touching, the fact that it was over the clothes in a public place, those don't rule out the possibility of an intentional sexual assault. Unfortunately, that does happen at bars. But they are the kinds of things that, when that shows up in the evidence, or the absence of the kinds of things that could reasonably lead a rational person to believe that, oh, this must have been intentional, it's absent throughout the course of the trial.
Is there case law that says a jury can assume that a person intended their acts?
If there is, Your Honor, I don't see how it could apply to a case like this. I know that there is case law about how, an accident instruction isn't always required because the jury instructions cover intent, but I am unaware of anything that would apply to the facts of this case because it would essentially transform this sexual offense into a strict liability crime. And we don't need intent of any kind of lasciviousness, right? There's no requirement that it has to be overtly sexual even. It can be inappropriate, it can be sexist, it can be anything. The kinds of intent behind that you usually find behind touching a female in that area when she's not asking to have that area touched.
Wasn't there evidence here that the jury heard that the defendant was bothering her friends who were there, trying to put his arm around their necks? And
There was, Your Honor. And without even getting into the inconsistencies, right? The fact that one of those people testified that it didn't happen, the other one didn't testify because she had a Fifth Amendment
right, there was an inconsistent
violation.
statement, but there was in
There's
fact
evidence, precisely, Your Honor. So as far as the Lattimore standard, yes, we can consider that. But what was the evidence? It wasn't even that he was flirting with them. Not only was it not the complainant, if there had been, we'll get a little closer, right? If there had been evidence that he was flirting with these other two patrons at the bar, that he was putting his arm around their waist, something.
I guess I don't understand the distinction with why would putting your arm around someone's neck bothering them as opposed to putting it around their waist. How is that?
I think there is a big difference, Your Honor, when we get into what the circumstantial evidence does show and the direct evidence, which is intoxication, clumsiness, somebody who's described as sort of larger than life. He is someone that everybody knows. The bartender testifies that he's out having a good time talking to people. These are the kinds of things that someone who is intoxicated and overly friendly does. We don't.
So speaking of what you're not arguing, are you arguing that there was evidence that your client was too intoxicated to form the intent?
Absolutely not, Your Honor. I am arguing the same thing trial counsel tried to argue to the judge, who I believe misunderstood the argument about why that accident instruction was necessary. It is not that the defendant was too intoxicated to recognize signs of non-consent. That would be absurd and offensive. The argument is that he was intoxicated. There was evidence that he was unsteady on his feet.
So no, that wasn't, are you arguing that the defendant was too intoxicated to form the intent to touch her?
Not that he was too intoxicated to form the intent, but that there was not sufficient evidence, any evidence, that he had the intent to touch her. I'm sorry, I hope I'm not talking in circles, but it does kind of feel that way when I'm trying to parse through.
This crosses into your accident instruction argument, right?
Yes.
That what was happening is, in his clumsiness, he ended up, into the other woman next to him.
Yes. And on its face, I think, without reading the transcript, without really trying to parse through and look for these plus factors, and most of the cases that I cite, I won't go through all of them, I know the court's familiar with them, most of them are in the context of deciding, is the touching indecent? Because it's usually obvious that it's intentional, because the defendant is interacting with the victim throughout. And there are so many of these kind of plus factors that I call them, for lack of a better word, that just you add them up and one by one they take away any reasonable inference that it wasn't intentional. But here we don't have that. And if the defendant, if the defendant was a woman and the evidence was, keep all the evidence the same, that this woman was bothering these other patrons, they were moving around, we wouldn't have the sort of what I think is a natural assumption that ordinary jurors could make, which is, well, there wasn't any evidence that it was an accident, so therefore it must not have.
But if the defendant wasn't a huge man,
Yes.
someone once said, you can grab women, they let you do it.
Yes.
He might, someone who wasn't a huge man might not have done this for other reasons.
Yes, Your Honor. And he is a huge man. His height, weight are not in the record. But getting back to Justice Tan's question, the testimony was that he was kind of putting his arm around their neck, and the jurors could see what we can't see here, his size and the complainant's size, and the person who he allegedly put his arm around her neck, all of their size. But we have to also look at what the judge himself seemed to understand or misunderstand about the purpose of the accident instruction. Because we have a jury of ordinary people from the community. I think it was an electrician, a car salesman, 2 machine operators. And the judge properly instructs the jury on evidence. Evidence, and this is on page 22 of volume 3. It talks about the evidence consists of testimony of witnesses. It goes into, so picture in your mind that all the evidence went into that box. The box is closed. And then a little further down, Your Honors, this is when I was really trying to put the lack of the instruction in the context of the entire jury instruction, as we must, because it does throw out the words intent here and there.
Well, that's important to hear. They're instructed not once but twice specifically, right? Because there's a lesser included assault and battery instruction was read, in which they also heard about the intentional, right? In addition to the indecent assault and battery jury instruction, which also the judge read.
Correct, Your Honor. And they were brief references in about 18 pages of jury instructions, and this is where I think that it's so important for us to step back, because those words jump out at us. None of us would have thought that, oh, even if this was an accident, it must be strict liability or something.
But if the judge had said, okay, you're right, I want to give an accident instruction, the district court model instruction on accidents starts off with something like, you have heard evidence that this may have been an accident. What's the evidence?
Your Honor, with all due respect, I don't know how to answer that, because what's the evidence that it wasn't an accident? Isn't it much more likely, crediting everything that this victim said, that this was not an intentional touching that happened suddenly out of the blue? It's not just that there was no evidence of sexual harassment, which does appear in every other case. There was no evidence of interaction whatsoever. And the reason that I think the accident instruction would have made a difference, it's actually not the definition of accident, Your Honor. Thinking about this in the context of what was going through that jury's mind in the deliberation room, it ties back into the argument about evidence that I was reading. And it's because the judge instructs, during your deliberation, one of you might say, well, what about this? What about that? Well, if this or that isn't already in the box, the evidence box that he describes, it's mere guesswork. Don't consider it. That was a correct instruction. But the part of the accident instruction that I think would have been really helpful, especially in light of the fact that the Commonwealth's closing really did just essentially argue, if you believe the complainant, he's guilty. As you just mentioned, Justice Grant, the first line is, evidence has been introduced in this case, which you may consider. And again, really thinking about what's in the mind of these jurors who, again, not nearly as smart and experienced and able to understand the intricacies of the law as the experienced trial court judge, who also did not understand what was being requested. I don't know how we can fairly say that this jury understood, and also the jury that came back 3-3 were deadlocked. We don't know what to do. I don't think that this was a close case with overwhelming evidence where you can point to so many other things. I see that I'm running out of time, but it really is the intent and the accident instruction arguments that I think are the most important and dispositive in this case. And if there are no further questions, I would ask the court to reverse the convictions. Thank you.
Thank you.
Good morning, Your Honors. Excuse me. May it please the Court, Stacey Gauthier for the Commonwealth. It is our position that the defendant's conviction of indecent assault and battery should be affirmed. First, with regard to the sufficiency of the evidence, we would suggest that the Commonwealth did present sufficient evidence that the defendant intended to commit an indecent or an offensive touching of the victim. And again, this is the Lattimore standard. We look at it in the light most favorable to the Commonwealth.
I think that may even be conceded somewhat. What about the accident instruction? Didn't that skew everything, not getting an accident instruction in this case?
So I would suggest, thank you, Your Honor, I'll skip to that. With regard to the accident instruction, we would suggest that there was no error on the part of the judge by failing to give that. That is looked at in the light most favorable to the defendant. And so looking at it in the light most favorable to the defendant, I would suggest that there just isn't evidence that there was no evidence that it was an accident. The instruction is required when requested, when there is, quote, when the accident is, quote, fairly raised, when some evidence of it is fairly raised. And here, it was not fairly raised, so I would suggest...
Well, isn't it raised by the circumstances of the gentleman's size, his intoxication?
I think...
Wasn't this the case where he had won the lottery and he bought a round for the bar and he was in this gregarious mood?
I would suggest...
He sits down at a crowded bar next to somebody on this bar stool. Wasn't it fairly raised that he could have just stumbled into the woman?
I would suggest that, no, it was not. The evidence in the light most favorable to the defendant was the defendant's statement that he was intoxicated that night, but he doesn't remember anything. So he doesn't remember whether it was intentional or it was an accident. There was also evidence that he had told the police officer that he had, quote, a bad weekend. But again, doesn't get into like what happened on that bad weekend. He did say that he had won money at a Keno and paid for a round of drinks, but that doesn't really give any context into like what happened when he paid for the drinks. So
the evidence
you have to look at the victim's testimony, I would suggest.
Evidence doesn't have to come from the defendant.
No, that's correct. Right? That's absolutely correct, Your Honor. So we look at the other evidence, which would be the statement of the victim, and the victim stated that he was, quote, a little unsteady on his feet, and he was, quote, somewhat intoxicated. She also, the bartender also testified that the bar stool, it had a back on it, right? And also it was high, so maybe his feet couldn't reach the ground, but there was a rung on the bar stool and on the bottom of the bar. So it's not like he's like trying to balance himself on some stool, right? He could sit down, he could put his feet down.
At this point, we're parsing the details. Isn't it, to get the instruction, it's just, is it fairly raised from those circumstances?
I would suggest it's not. It's too general. We don't know. I mean, sure, he paid for a drink, but we don't know, did he actually have to grab from his wallet, or was his wallet in his front, maybe he's got a front pocket of his T-shirt.
Aren't those the things that are argued to the jury once you get that instruction?
I would, no, not in this case. We don't know. Again, there's just not enough evidence. The only evidence is that he was so intoxicated, he couldn't remember anything. And then there was her testimony that he was a little unsteady on his feet, right? Not on the bar stool, on his feet, and that he was somewhat intoxicated. And I think it's a leap to go from that to he couldn't stand on the bar stool when he was like trying to pull his wallet out to pay for his drink. I think that's too big of a leap. However, if the court does find that the accident instruction should have been given, I would suggest that there was no error because the judge gave instructions on the indecent assault and battery and the lesser, specifically in the lesser included of plain assault and battery, where he said, first, in indecent, he said that the touching must be intentional without legal justification or excuse. So obviously, if you're falling off the bar stool, that would be, an excuse. And then even more specifically, he actually addressed accident in the lesser included assault and battery instruction, where he said that the defendant would have to consciously and deliberately intend the touching to occur, and that the touching was not merely accidental or negligent. And then he also instructed on the Commonwealth's burden of proof, and we look at the instructions again as a whole. It's presumed that the jury followed the judge's instructions, and I believe there is also cases that say, it's presumed that the jurors have some type of sophistication, when they're making their decisions. But I'm also just, sorry, sorry. I just also wanted to add, there was a case that the defendant had cited in his reply brief, Ferguson, that had to do with an assault and battery with a dangerous weapon. And what the court said in that was, normally a judge's failure to give an instruction in the defense of accident is cured by a proper instruction defining the elements of, in that case, assault and battery with a dangerous weapon. However, in that case, the judge did not instruct properly on ABDW, so the conviction was reversed. But here, the judge instructed properly on indecent assault and battery and on assault and battery. So for those reasons, even if you find that the accident instruction should have been given, there was no error that would require reversal because the judge instructed properly on the other two charges.
Could you move on to the other issue regarding the fresh complaint testimony and the excited utterance and the interplay between them?
Yes, yep. So we would also suggest that there was no error in the admission of the first complaint evidence or the excited utterance prior to trial. There was some issue about who was the actual first complaint witness. The judge conducted a voir dire of the victim as well as her friend who was in the bar. The judge determined after the voir dire that this friend Amanda, was the first complaint witness. And so he let in the victim's statement to her that the defendant had touched her in the crotch area. There was some conflicting evidence as to where that statement was made, whether it was made in the bar right after the statement, that's what the victim testified to, or whether the victim went outside after she made the statement and said it to Amanda. That was what Amanda's testimony was. And then, so I would suggest that was properly admitted. But then the judge also, in addition to the first complaint evidence, he also let in an excited utterance when the victim was sitting at the bar and the defendant had first touched her. She jumped up and said something to the effect of, "Keep your hands off me. Did you just effing touch me?" And so I would suggest that was properly admitted. She testified that it was unexpected, that it was unwanted, that she was upset and angry after. Her friend testified that after the incident happened, she was also upset. And I would suggest there was no error in the judge letting both of that evidence in. They served separate purposes. The first complaint evidence served the purpose of the victim making a prompt complaint of a sexual assault, which is the purpose of the first complaint.
Even without that so-called fresh complaint, it was clear because she had made a statement in public. So what was the purpose of any fresh complaint after that?
The purpose would be, but the statement that she yelled when she jumped up.
Excited utterance.
Yeah, that was not a complaint of a sexual assault, right? That was an unwanted touching, and that would certainly go to one of the elements of indecent assault and battery, was that it was an unwanted touching. The second one was that it was a complaint of a sexual assault, because now she's going on and saying, essentially the touches that it was in the area of her crotch. So I would suggest they serve two different purposes. One, which was the excited utterance that that it was an unconsented to touching, and then the other one was that it was a prompt complaint of a sexual assault. And also, I would also just suggest that multiple instances of her making complaints was not objected to by the defendant, and I would say inferably because that was part of his defense. If you looked at, his closing argument as well as the two witnesses he called, part of his case was pointing out, or attacking her credibility and pointing out inconsistencies in her statements. And the defendant's trial attorney also pointed out multiple instances where she had made complaints and then used that at the end, to argue that, her credibility was not good.
Could you say something about the judge's consideration of the unrelated restraining order affidavits in sentencing?
Yes. So again, in support of the defendant's recommendation that he be given probation, he had provided the judge with, I believe it was 3 character references. And so, the judge obviously read those and took those into consideration, but in looking at the in looking at the defendant's record, he noticed that there was, I think there was 2 old restraining orders. They were expired, they were ex parte, and so he asked the clerk to go pull those. He said that he wanted to take a look at those, and he said that, the recommendations by the defendant had painted one picture of him, but these might paint another picture of him. And so he did take a look at those, and I would suggest that was proper. There's lots of things that judges can take into consideration in sentencing, and he certainly made clear at the end that they were filed ex parte, they were only issued for a short period. He then also gave the defendant's attorney a chance to also review those affidavits and respond to those. Defendant's attorney did. He said, well, one of these women is still friends with the defendant and had, visited him recently. And so then at the end, the judge said, that he was basing his sentence based on everything, everything that I've heard at this trial, a review of his record, and then also in consideration of the affidavits. And I would suggest that this is a sexual assault, and he's certainly allowed to consider the character of the defendant and his amenability to rehabilitation in sentencing him. So I would suggest there was no error in that.
You characterized them as ex parte affidavits.
That's what the judge had characterized them, I believe, as.
So do we know if they were issued after are we looking at affidavits that were issued after a 2-party hearing?
I'm not aware. I don't know. Maybe it might have said, maybe possibly in the record, but I don't, off the top of my head, know. I know
Do you think it would make a difference if the affidavits were considered and it was simply ex parte and there'd never been a 2-party proceeding versus one that issued after a 2-party hearing?
I mean, I took it to be that they had just issued as a result of an emergency restraining order, and there had been no 2-party hearing, and that's why he said they were ex parte.
So why would this be a reliable piece of information for a judge to rely on in sentencing?
Well,
anybody could come into court and make all kinds of wild accusations, and where there's no other party to.
I mean, in the same vein, Your Honor, anybody could write a character reference and say anything. So I don't think that they're any more or less reliable than what he submitted in support of his request that he only get probation. And I think the judge considered that. He said, I know they're ex parte. I took that to mean there hadn't been a hearing. I could be wrong, though. But I don't think they're any more or any less reliable than what he submitted, which were not under the pains and penalties of perjury. And if there's no further questions, I will rest in my brief for anything not addressed.
Thank you.
Thank you.
Thank you to the parties. The matter is submitted. The next case on the list is Commonwealth versus Greg McCollum, 24P1308. I'll ask the parties to approach.
Good morning, Your Honors. Attorney Justin Dashner for Mr. McCollum, the defendant in this matter. May it please the court. Mr. McCollum's conviction stemmed from a process that broke down the minute he was denied the right to counsel. All the errors that occurred after the fact are compounded by this initial violation. Mr. McCollum, throughout the process, was represented by several attorneys. The record is clear from the start that that when the attorney on November 1st, 2021 moved to withdraw, that this was due to a breakdown in communication, a disagreement over Mr. McCollum's wish to use a head injury expert. A not unreasonable request considering the nature of the case. This was a case that involved a head injury and an OUI, so a head injury expert could certainly help the jury figure out if this was a head injury or truly an OUI. However, after that counsel, the judge throughout this process showed impatience with Mr. McCollum and suggested that this would be his last chance at an attorney.
Although he kept, the judge said that each time the attorney moved to withdraw, right? And there were at least, I counted, and just tell me if I'm wrong, at least 7. I think his trial attorney was his 7th and 8th attorneys, right?
Yes,
yeah.
I believe either 7th, 8th, or 6th.
Right.
But
So each time the judge said, well, this is going to be your last lawyer, but then he gave the defendant another lawyer anyway, understandably, because obviously I think usually having an attorney makes the process easier, right?
Yes.
And so he did in fact go to trial with the 2 attorneys, correct?
so,
And he did call Dr. William Stewart.
yes, ultimately he did.
So how is he prejudiced by the fact that at some point there was an issue about whether or not a different lawyer would have let him call a head injury expert?
Well, that's not so much of my point as that the entire year in which he was not represented by counsel between 2022 and 2023 was a time frame where he filed various motions. They were critical stages of the trial where a motion to suppress was never filed. Motions to dismiss were not necessarily argued. He filed a motion in limine regarding potential evidence and argued it. All of these things were done without the assistance of counsel. Denial of the assistance of counsel is structural. So I don't think he has to show prejudice in that way. He does ultimately, shortly before trial, get what I would argue was the appropriate sort of response is the colloquy by the judge, where he goes over the pitfalls of representing yourself, the exact conduct that he is asking Mr. McCollum not to do, and he proceeds with that attorney at that point. He then has
So let's say a case is pending for a year, and on one of those dates there's a hearing, and the defendant's lawyer doesn't show up, and the judge says, well, it's a blizzard or it's COVID and there's no other lawyers here, you can't have a lawyer today. Does that mean that the defendant can never get a fair trial if he doesn't have a lawyer on one pretrial hearing?
No, Your Honor, that's not at all what I'm arguing. Certainly, pretrial hearings throughout the process happen. Attorneys are not present for whatever reason, and this isn't denial of counsel. He was specifically denied his right to have counsel other than as standby counsel for an entire year in which almost nothing was done on the case other than what Mr. McCollum did himself. He did eventually proceed to trial with counsel, which he had for about a month before trial. No motions to suppress were filed at that time. No motions for continuances were filed. Then he went to trial, and after conviction, there were some issues at the trial level, which are discussed down below. And after the motion for new trial was filed by that defense counsel, his trial counsel, that trial counsel moves to withdraw. And that motion's allowed. And then Mr. McCollum has a second offense bench trial in which he has no attorney present. He has sentencing, which he has no attorney present. Certainly, that is a critical stage of the trial. Not only that, the second seat counsel, who was there for the first part of the trial, never moved to withdraw, was still counsel of record, and never showed for the bench trial. So essentially, Mr. McCollum, what I'm arguing is that the judge never gave Mr. McCollum sort of the express warnings of what conduct was prohibited, even giving that his misconduct rose to the level that justified waiver, which I'm not conceding. That explicit warning was never given until after he'd already represented himself for a year. And then, after that, not only was the specific warning not given, but there was no knowing and intelligent waiver done by Mr. McCollum. So moving on to the fact that the medical records came in to the jury with an unredacted statement saying this is a second offense OUI. This is clear error, clear propensity evidence, which is highly...
And both parties concede that, right? This
Yes.
was error.
Yes.
So what's the question?
Yes. So the question is essentially is prejudice, right? This was argued at a motion for new trial. However, counsel concedes on the record that this was something that they reviewed and they missed. They made a mistake. This is something that should have been seen by counsel. The record is clear, therefore, it is appropriate to argue on direct appeal that this was ineffective assistance.
And I think the Commonwealth concedes that, right?
Yes,
They're
they
going to
do.
get up here and say, just as they did in their brief, that, well, the case was so strong that,
Yes.
right? So how do you respond to that?
So the response to that is that this does not stand on its own. It stands with all the other errors that are alleged later in the brief. And
Was your client represented by counsel at the moment when the exhibits went to the jury?
yes, he was. Yeah. So counsel essentially reviewed and, said he reviewed for redactions. The second seat counsel said he reviewed for redactions, and then it went to the jury. He was counseled all the way through verdict up until and after a motion for new trial was argued by trial counsel, who, of course, didn't raise an ineffective claim on that issue at that point.
Can the Commonwealth prevail on this claim if they can show that the evidence was overwhelming? And was it so?
I think that's the only way in which they could prevail, but I don't believe that is the case. And the reasons would be essentially...
Don't you have multiple witnesses giving testimony regarding impairment intoxication?
Yes, multiple witnesses talk about how he's unsteady on his feet, stumbles out of the car, but
These are not police officers,
Yes.
different civilian witnesses.
Yes, but all these things could as well be attributed to the head injury. And that's why this does tie into my third argument, where Mr. McCollum was completely undercut from making the head injury argument that he wanted to make. So not only was there not overwhelming evidence, but this is also compounded by some of the only admissions done by the client were in the back of a police car, and this was done after an unmirandized, well, there's no foundation to believe that Miranda was actually given at that point by that officer. The Commonwealth has to have appropriate foundation to elicit these statements and that they were given involuntary. The Commonwealth argues in their brief that this was a sort of fait accompli, that it was futile, that even if the defense counsel had objected, they would have come in. But there's nothing on the record showing that to be the case. We don't know, other than making assumptions, that Miranda was actually given by this officer, and not just that, but more importantly, that Miranda was knowingly waived by the defendant. There's no evidence of that in the record. So counsel's failure to object to these statements as they're coming in was also ineffective and is clear from the record. I do cite to Commonwealth v. Mullen in my brief, which is a very similar case. It is...
But Mullen doesn't, aside from the fact that it's unpublished, it doesn't really have any facts, or very many facts.
Sure.
Could the judge here decide that all of these symptoms of intoxication, defendant throwing up outside the car window, going faster than the other traffic, 4 o'clock on a Friday afternoon in Gloucester, causes a 4-car accident, has these extra large, extra strong, cold beer cans that he hides from the police, and a whiskey bottle. Couldn't the judge decide, having seen those witnesses, this case is distinguishable from Gonsalves and Mullen?
Yes, Your Honor. I don't think so. First of all, addressing the unopened alcohol, it's clear all the alcohol was unopened. So that on its own, anyone can buy alcohol at the store and bring it. Hiding it is certainly an issue. And that's part of the statements that he talks about why he hid them later that were problematic and should have been objected to by counsel at trial. Understanding there was a lot of evidence here, there was also evidence of the head injury. And that brings me to the third point, which is where the expert is told by the judge that he's not allowed to explain certain terminology that appears in the medical record. Now, he's not making any sort of diagnosis of the defendant at that point. The expectation was that he would discuss about what the term unremarkable meant as it relates to head injuries and whether that means he had a head injury or not. The judge does not allow that expert to go into that detail, the exact thing that a head injury expert should be allowed to explain to the jury to help them understand the terminology within the medical records. This is, to me, very similar to the Commonwealth using some sort of drug expert where they help talk about street terminology and things like that to help interpret for the jury what they have before them so they can better understand the medical records that they have and what exactly.
Could a drug expert testify about what a different police officer meant by a word in his police report?
It's possible. They testify to what they hear in common drug transactions and stuff all the time. So that's what this would be, is essentially what does unremarkable mean in the context of a CT scan, not directly as it relates to Mr. McCollum. And I think that was agreed to by counsel. But all of this was compounded by the eliminate order in which the judge tells both parties that they're not to use the word concussion. There's no evidence that he was either diagnosed with a concussion or either had a concussion or didn't have a concussion. So he does not want that word used. However, the Commonwealth in their closing uses that word 3 different times to suggest these medical records explicitly say he doesn't have a concussion, which is not the case.
Well, wasn't the prosecutor simply arguing, I mean, it was argued that these symptoms could be as a result of a head injury. So I was trying to parse what were the judge's instructions. Don't say concussion, but head injury's okay?
Yeah, exactly. And I think it's because he viewed concussion as an actual medical diagnosis that wasn't given, as opposed to just talking about, it was clear that he was hit in the face based on the booking photo.
So what's the real violation here, or the real harm here? The argument was made, wasn't it, by defense counsel that these symptoms could be consistent with a head injury, right?
Yes.
And the prosecutor said, he used the word concussion, and he says, it's not a concussion, it's intoxication. But if he had said, it's not a head injury, it's intoxication, that would have been okay in terms of the judge's rules.
Well, I think the problem is twofold. First, the explicit instruction not only to not say concussion, but also not to bridge the gap between what it says in the medical records and what that means, because we don't actually have evidence that he didn't have a head injury and that he wouldn't be exhibiting signs of a head injury. But what happens is the Commonwealth comes in their closing and says, this person did not have a concussion. Whether he uses head injury or concussion is not what the medical record states. It's a misstatement of the medical records. And also, perhaps if the expert had been allowed to talk about what unremarkable meant in terms of the CT scan, they wouldn't have been allowed to then, the prosecutor would have had a more difficult time arguing that in their closing that this affirmatively meant he did not have a concussion. Therefore, there's no way he could be exhibiting the signs and symptoms of a head injury as opposed to intoxication. So this goes directly to the heart of what the defendant's defense was at trial. That was the entirety of the defense, of the OUI charge, was essentially head injury versus intoxication. And these misstatements were highly prejudicial to their case. And If there are no further questions at this time, I see I'm out of time. Remainder on my brief and ask that the conviction be vacated. Thank you.
Thank you.
Good morning. May it please the court, Jennifer Cohen for the Commonwealth. The Commonwealth is asking the court to affirm the defendant's 2 convictions for negligent operation and a second operating under the influence. As to the first issue raised by my brother, it's the Commonwealth's argument that the defendant's right to counsel was not violated pre-trial or at his bench trial. At the outset, I would note that the Gibson case is about forfeiture, but it provides helpful guidance for involuntary waiver in that the court says Gibson was also a case where successive attorneys moved to withdraw. The Gibson court found that a remedy in this sort of situation would perhaps be involuntary waiver rather than forfeiture because the conduct of the defendant didn't rise to the level required to meet the forfeiture strictures. So I would say it doesn't matter that it was the attorneys withdrawing rather than the defendant seeking to dismiss his attorneys.
Was the defendant properly informed by the judge about the behavior that he needed to stop in order to not risk not having a counsel appointed to represent him? Because I didn't see anything specifically in the record, right?
No, so I would agree with Your Honor that he doesn't explicitly state you cannot threaten BBO complaints or some such, but I would argue that the totality of the judge's warnings to the defendant established that he's very frustrated that this defendant may be...
It's clear that he's frustrated.
Yes. That he may be doing this purposefully to delay, and I think the point of the judge is you are not getting along with your attorneys and you need to cooperate and listen to your attorneys, and if you can't work with this attorney, I will give you one more chance. And if your attorneys continue to seek to withdraw due to a breakdown of communications, then you're going to have waived your right to
Does the judge need to inform the defendant?
So in Gibson, I believe, there is a parenthetical talking about the behavior that that a judge should warn the defendant not to engage in certain behavior. And I think in that case it says to tell the defendant not to file BBO or threaten BBO complaints and not to threaten a lawsuit. But I think it would be, I suppose, counterintuitive to warn a defendant no more BBO complaint threats, or you're going to waive your right to an attorney, and that at the next date he's threatened to sue rather than threaten a BBO complaint. And I think the crux of the warning is what is important here.
And what was the crux?
The crux is get along with your attorneys. I think don't put your attorneys in a position where they have to withdraw for a breakdown in communications. I would agree with my brother that the colloquy conducted as far as that first waiver is, I guess, not best practice, that the second waiver, the colloquy, was perhaps what should have occurred in the first instance. But I would say that even if your honors find issue with that first waiver, this was pre-trial. The defendant had representation at the jury trial, and I think in means, which of course was about forfeiture and not involuntary waiver, the court said that the forfeiture of counsel at a non-trial phase does not deal as serious a blow to the defendant as at trial.
He went unrepresented, though, right? So after the motion for new trial was denied, he actually didn't have a lawyer at the second and subsequent stage and sentencing.
Yes.
And it was a little bit confusing in that the supervising attorney, the one who wasn't there for the latter part of the trial, hadn't filed a motion to withdraw and hadn't, at least my understanding of the record, actually withdrawn. but the defendant went forward on his own
Yes, so.
at those stages.
Of course,
right.
my argument pre-trial, I do
So
agree
how do you-
that the
how do you-
bench trial is a separate and
So
distinct.
can you address that?
Yes, so on the date that his sixth attorney was reinstated, there was a colloquy that the judge went through, which I think was kind of what you'd expect from a colloquy, and he does warn the defendant. Again, I probably have the same issue that the warning is to get along with your attorney. I can't overcome that, I suppose. But he's given the colloquy, he's warned what self-representation is going to look like. At that point, we already know that he is competent. So I would say that the involuntary waiver for the bench trial was proper, and so there's no reason to find that he was improperly deprived of counsel at the bench trial and at sentencing, although I agree they are critical stages.
What do you have to say to the defendant's argument that maybe if he'd had counsel at a pretrial stage, he would have moved to suppress and some of this evidence wouldn't have come in?
Well, I suppose my argument rests on the fact that for the majority of the time, the pretrial time, he was represented by counsel, and these motions were never filed. He did successfully engage his head injury expert who testified at the jury trial. So I would just say that there doesn't seem to be anything in the record that the time pretrial, I'm just going to have to look at my notes for the proper wording, that these hearings, that the defendant's substantial rights were at stake such that any of the hearings during that period he was unrepresented pre-trial constituted a critical stage of the proceedings.
Can you address the 278 Section 11A violation that took place?
Yes, Your Honor. So I do agree that it is an error on its face, and the court can consider that for the first time on appeal. I would note that in the published cases that deal with these kinds of errors, the court has reversed on a finding that there was an additional error beyond the 278 Section 11A error.
But every case you cite is a reversal.
Correct. And my argument, Your Honor, is that there were no other errors in this case such that reversal would be required. Where we're agreeing that there is this one error, I'm arguing that it's not enough to require reversal on that error alone.
The primary case you cite, there was actually, it was caught, right? It was caught during,
Yes.
in the midst of trial, and they sought to remedy it through a curative instruction. Even that wasn't enough.
So in one of the cases that I've cited, Whitlock.
It was Whitlock, right?
Whitlock, I think there was no instruction there. The defendant didn't ask that there not be an instruction given.
Although he was given the choice, and
Yes,
he
he was
elected
given the
not
choice.
to.
I agree. But that error alone didn't amount to the reversal. It was that in addition to the judge's incorrect instruction as to proximity. Those two errors in combination amounted to prejudice warranting reversal. And I would agree that in Gonzalez, the failure to redact was caught prior to the verdict being returned. There was an instruction, but I would also say that the court in that case didn't seem to find that the instruction was particularly helpful, where it was clear the jury had focused on the issue.
Well,
But
here
even
the
there-
jury told the judge, right?
Yes.
They volunteered and said, hey, actually, we saw this, and we tried to put it out of our minds and exclude that from consideration. So we don't really know, though, right? We don't know how much that influenced the jury.
Sure.
And
I
they
think-
didn't have the curative instruction, which tells them you can't consider this,
Yes.
right? So for all they knew, they could have taken it for substantive evidence.
And the Commonwealth's main argument isn't that there couldn't have been some kind of focus on this, and I don't think that's necessarily fatal to my argument because of what happens in Gonzalez. I'm agreeing that there was error, and, the jury clearly were aware of the error. There's no disputing that. But even in Gonzalez, where there was an instruction given, it wasn't the failure to redact alone that led to reversal. It was the failure to redact coupled with the admission of the defendant's post-arrest silence through 2 different witnesses and on 3 occasions. So my argument is that, yes, this happened. It's possible that the jury focused on it, but this alone doesn't require reversal.
Well, the cases don't say that you need more.
No.
Right? It's just in every case, the courts had mentioned that there were other things wrong.
Yes, so I guess I'm
Isn't
relying.
this about the most prejudicial thing that can happen in any case? This person did this before, particularly in an OUI. I mean, it has particular force there. He's been convicted before. So if we're on the fence as to whether he was drunk or not, he probably was.
It's certainly not great, but it is the Commonwealth's position that this alone wouldn't have amounted to reversal, and that's also in light of the strong evidence that the Commonwealth presented as to intoxication in its case.
What about the prosecutor saying, this wasn't a concussion, after the judge instructs him specifically not to do that?
Yes, there were some things that would have been better left unsaid, but I would argue that while she shouldn't have said concussion, I think her using the term concussion was also an implicit agreement that Dr. Stewart was talking about head injuries and was talking about a concussion. I think it was kind of the elephant in the room that we're talking about a concussion. And outside of her making those, using that word on 3 occasions, I would say that the remainder of her argument was consistent with the medical records, and I think was a proper interpretation of the medical records.
Wasn't there actually a witness who testified about concussions?
There was.
A lay witness who said that,
Yes, there
I
was,
was
Your Honor.
fine that day, but concussions can appear later.
Yes, on cross-examination, trial counsel did get out of that witness that she wasn't specifically diagnosed with a concussion at the hospital.
So the defendant's theory was out there in that sense.
Yes, and I think the defendant's theory was out there in the actual medical record themselves. If the jury had, presumably they did look through all of that evidence, there were at least a couple of occasions where the medical records stated something to the effect of, you may not have been diagnosed with a concussion now, but you could experience symptoms later, and look out for those, and they could be consistent with a concussion.
So doesn't that highlight the egregiousness of the error in the prosecutor mentioning this wasn't a concussion?
I think, again, it should not have been said, but it is true that the defendant was not diagnosed with a concussion. Whether it was head injury or a concussion, the medical records don't say that the defendant was diagnosed with that in the actual medical records. I think trial counsel could have argued, based on the evidence in the medical records, that stated the defendant may have experienced these symptoms later. I'm not sure, but I think the evidence that trial counsel wanted to get in came in through those medical records. And notwithstanding that, I think as to Dr. Stewart's actual testimony, as the proponent of the evidence, trial counsel basically said before the trial started, I'm not going to ask him, about a concussion and why that wouldn't show up in the medical records. So there was never any evidence any argument or proffer before the judge that sort of testimony should have come in. And I think even at sidebar, when the objection was made by Commonwealth, again, there was no kind of proffer about why this evidence should come in. I think there was kind of an agreement from the beginning that wasn't going to be delved into. If there are no further questions, I'll rest on my brief.
Thank you.
Thank you very much.
Thank you to both parties. The matter is submitted. At this point, the court is going to stand in a recess.